SJC-13211, Commonwealth v. Exxon Mobil Corporation.
Okay, Attorney Anderson, whenever you're ready.
Thank you, Your Honor, and may it please the Court. My name is Justin Anderson. I represent Exxon Mobil in this appeal. The anti-SLAPP statute provides a special procedure to protect defendants from civil claims that are based on petitioning activity. In this case, the Superior Court found that petitioning activity formed the basis for the state's claims. The Court also found that the statute requires an all-or-nothing result. It's a quote from the decision. And if there was a basis for the Attorney General's claims that was not petitioning activity, then our motion was supposed to be denied.
So, counsel, before you get into the specifics of, the three-part or two-part test, however you want to consider it, I guess here's where I'm troubled, and maybe you can address this. So the complaint, or the amended complaint, as I understand it, alleges that ExxonMobil committed a fraud against its investors and against the Massachusetts public by engaging in a 40-year lie, as to its future prospects and as to what its products contribute in terms of the degradation of our atmosphere. I'm wondering why the anti-SLAPP statute is even available to you or your client to shut down an enforcement action by the Attorney General in that circumstance.
Your Honor, the statute applies to any, I'm going to quote the language, to any case.
I understand. So before you get into the statute, I'm just wondering why you think the legislature, in passing the anti-SLAPP statute, would have intended for it to apply to enforcement actions by the Attorney General, period, full stop. Well, that is, the intent of the anti-SLAPP statute is to protect private parties in using the court system in order to punish petitioning activity. And it seems inconsistent to me with that underlying purpose of the anti-SLAPP statute to allow it to be used against the Attorney General in her enforcement capacity.
Your Honor, the statute provides the answer. The intent was to make this remedy available in any case where civil claims were brought.
But we're supposed to interpret statutes reasonably, sensibly, consistent with what we think the legislative intent is. And I'm wondering where you think that makes any sense, to shut down enforcement actions on behalf of the people of the Commonwealth against fraudulent activity by using the anti-SLAPP statute.
But, Your Honor, if you take that argument to its logical conclusion, well, how could we bring a 12b6 motion against the Attorney General when it brings a civil action under 93A? That would potentially shut down an enforcement action. How could we move for summary judgment against the Attorney General? That could shut down an enforcement action. How could we go to trial and win, like we did against the New York Attorney General, who brought a similar case? That could shut down an enforcement action. When the Attorney General appears in this court to bring civil claims—
But in those cases, you don't have the First Amendment, right? You're saying the Attorney General is punishing us for stating our position on global warming, right? And so you have a defense, right? The government is punishing us for speech. That's the First Amendment. That seems different in kind to me than 12b6, failure to state a claim, or a motion for summary judgment, failure to prove your claim. You have in the Constitution a defense. Why would the legislature need to provide you the anti-SLAPP statute to supplement that defense?
To avoid having to invoke the defense at summary judgment or trial. The anti-SLAPP statute provides a mechanism to have a case that is brought against someone for petitioning activity dismissed at the outset, before burdensome discovery is imposed on the party, before we have our executives come in to give testimony and depositions, before we're dragged into a courtroom where we have to defend ourselves. All of this happened in New York. The anti-SLAPP statute says if the case is brought against you because of your petitioning activity, you have an efficient remedy to dispose of that case at the outset. And there is no indication that the legislature intended to exclude the Attorney General's civil cases from the scope of the anti-SLAPP statute.
What about in the statute that says, you know, instead of saying a party, including the Commonwealth and its officers, as other parts of the statute say, the anti-SLAPP statute does not provide that. So section 6E through 6G defines party to include the Attorney General, whereas 59H does not. Can I ask you to address that?
Of course, Your Honor. So Section 6, E, and F are analogous to Rule 11, where after you've won, so after ExxonMobil has won on summary judgment, won on a motion to dismiss, we can then bring a motion under Rule 6F for costs and fees. And that's what that provision allows for, to a victor, if they can then show, like in Rule 11, that the litigation was
So
brought in
that-
bad faith.
So
But
sorry,
anti-SLAPP
counsel, but just that goes to the substance of what those provisions address. I'm wondering why I'm trying to figure out the legislative intent, right? That's the whole point of the statutory construction game, right? And in 6E, F, and G, the legislature says, and these sections also apply to the Attorney General. In section 59H, it doesn't say that. So normally, the absence of the same language in a different part of the statute, in the same chapter, you would indicate that a party does not include the Attorney General.
Your Honor, there are special rules in the civil procedure that require there to be an authorization of law before fees and costs can be recovered from the state. And so it very well could be that the difference between what is set forth in 6E and F is the need to expressly authorize that recovery, whereas 59, which is silent, it has no exclusion of the state when it's a civil plaintiff, doesn't need to address that question because the recovery of fees is set forth, and if it doesn't provide the authorization to recover those fees, then we might not be able to recover fees. But that doesn't exempt the state. It doesn't exempt the state from the anti-SLAPP statute. When the state chooses to be a plaintiff in a civil action.
What you've done, though, is you've basically using the anti-SLAPP statute to shut down all enforcement for years. That raises all kinds of issues that are different from an ordinary case. You're turning the anti-SLAPP procedural posture into a vehicle that shuts down the chief enforcement officers of the state's ability to do even discovery. Don't you find that a real problem? You think the legislature meant you to use this procedural device as a way of preventing discovery, investigation? I mean, you've taken this case and shut it down for now 2 years, 3 years? They haven't even been able to do the discovery they're supposed to do. That's why the anti-SLAPP statute is totally different and why it shouldn't be applied in this context, it seems to me.
Your Honor,
You're not even getting to the merits.
Your Honor, that's factually
That's
not
just,
correct.
it is. You haven't allowed any, you're shutting this process down prematurely through an anti-SLAPP statute that's not designed for this purpose. It seems to me it may even raise constitutional questions about the ability of the AG's office to do investigations in general.
Your Honor, the Attorney General did do an investigation. We didn't bring an anti-SLAPP action when they when they issued a CID. According to them, they've conducted a robust investigation that included obtaining documents from multiple third parties, and they brought a complaint against us based on that investigation,
And then when you lost that, now you've brought an anti-SLAPP and it shut it down again, right?
We haven't shut anything down, Your Honor. They proceeded to obtain documents from through subpoenas. We had a conference in front of Judge Krupp last week where they asked for the first time that we have a Rule 16 conference. We did not oppose. The judge said, let's have it on May 5th. We said, we will be there. We have not dragged our feet on discovery at all. Now, we did propose to them that while this case was pending and while their motion to strike was pending, that we consent not to engage in party discovery. That was our proposal. They were free to reject it. They could have asked for a conference, a Rule 16 conference, a year ago. There's nothing in the statute that automatically stays discovery while an appeal is pending, and this was decided by Judge Green a year ago. So the idea that ExxonMobil has unilaterally prevented the Attorney General from obtaining evidence in this matter is false. We have not done that.
We'll hear from them on that.
Your Honor, what we have done is use a remedy that the legislature has authorized. The idea that the government can be trusted never to bring legal action against someone because they disagree with their speech runs counter to the fundamental concept and the fundamental core principle behind the First Amendment itself. The First Amendment protects us from the government.
But that's my point. Right? You have a remedy. You have the First Amendment against the AG.
We do.
If, in fact, the complaint, I read the complaint, it doesn't punish your client for its speech. It alleges, and this is only an allegation, right, at this point, that there's been a 40-year fraud committed on investors in your company, in your client's company, and on the American public, including the good people of Massachusetts.
Your Honor, it does more than that. For instance, on paragraph 26, it says ExxonMobil's misrepresentations about and failures to disclose those risks about climate change have, quote, delayed the needed transition to clean energy around the world. They're saying our petitioning has delayed the transition to clean energy. They have on page 1, or paragraph 195, said that our speech has, quote, forestalled a strong policy response to climate change. They've said that we paid for Mr. Soon to go in front of the U.S. Congress, this is a quote, U.S. Congress, state legislatures, and the media in a matter that was intended to reach the general public.
But counsel, aren't those just the consequences of the alleged misrepresentations?
Your Honor, the alleged misrepresentations are the statements that ExxonMobil has made about its views on climate policy, on energy policy. Even today, what ExxonMobil has said is that the world is not ready to move away from oil and natural gas. What are we hearing today? That Joe Biden, the president of the country, is not only asking ExxonMobil and other energy companies to drill more oil, he's asking Saudi Arabia, Venezuela, and the idea that ExxonMobil has committed fraud because 6 years ago, 7 years ago, the company said, we're not, the world is not ready to transition away from fossil fuel.
For a second? Let's take the cigarette cases. The cigarette companies were also saying that cigarettes don't cause cancer. Would they have had an anti-SLAPP protection the same way you're arguing? I'm just curious, because it sounds to me the exact same argument you're making would have applied to the cigarette cases, because they're saying, without any factual basis, that's the allegation, that cigarettes don't cause cancer. And then that appears in their marketing devices. Are you saying they also had anti-SLAPP protection? And if you're saying they didn't, why are you different?
Your Honor, I think the difference, and I have not read the complaints that were filed against the tobacco companies. The complaint that was filed here refers explicitly to the fact that we petitioned and the fact that the Attorney General doesn't like the results of our...
I think the tobacco companies were doing something very similar. They said cigarettes didn't cause cancer. And using our low-tar cigarettes is a good thing. There was a lot of that in the cigarette cases. The AG's investigation showed that was factually inaccurate and knowingly factually inaccurate. But again, it sounds to me like that's, in your view, protected by anti-SLAPP because the cigarette companies had the right to advocate that cigarettes don't cause cancer.
Your Honor, I can't speak to all the aspects of tobacco. I can speak to the aspects of this case,
Why don't
which
you
have to do
start
with
with the
energy and climate.
hypothetical? Start with the hypothetical, and then you can distinguish it.
Well, Your Honor, tobacco is a consumer product, and there was an allegation that there was a property in the consumer product that caused a harm that was concealed. Here, the Attorney General concedes that our products work as advertised. There's no allegation that our Synergy 1 gasoline does not have lower emissions than standard gasoline. There's no allegation that Mobil 1 doesn't reduce friction so that there are fewer emissions. They don't say that's the misrepresentation, that's the omission. What they say is fossil fuels can never be part of the solution to climate change. And that's what they accuse us of misrepresenting. And that's why the judge found that some of our statements in the complaint are protected petitioning activity. And what she didn't, and in violation of this court's decision in Blanchard, she said, all or nothing, that's it. And since there are non-protected aspects of the complaint, I can't grant your motion. Under Blanchard, this court said 5 years ago in Blanchard, that's not right. What you need to do is segregate the protected petitioning and put it over in this column, move the other statements into the other column, and then dismiss the claims, or at least consider dismissal of the claims insofar as they are based on protected petitioning activity. The court didn't do it because it didn't cite Blanchard. It cited an appellate court decision from years ago that said it's an all or nothing result. That was clear error. That can't be allowed to stand. That's inconsistent with the framework that this court has set up in Blanchard, which, by the way, did exactly that. The hospital in Blanchard made statements, and primarily, as the court held, was to protect their reputation. The primary purpose was to protect their reputation. And they made those statements internally and to the Boston Globe. The court said the statements that were made to the Boston Globe are protected. Defamation claims cannot be based on the statements to the Boston Globe. And the court said, but you can proceed on the statements that were made internally, move to the next.
So if you lose on the first issue, meaning whether the anti-SLAPP applies to the AG's office, then it is an all or nothing proposition. But if we agree with you that the anti-SLAPP can be brought against the AG's office, we should be parsing their claims and dismissing some of them, saying some of them are eligible for dismissal under the anti-SLAPP.
That's right. If you follow the Superior Court's judge's readings, I mean, the Superior Court judge did not hold that the statute doesn't apply to the Attorney General.
She thought that was our call, not her call.
Right, Your Honor. And so she applied the statute to the Attorney General, found that some of our statements were protected, but couldn't grant any relief to us because she erroneously felt bound by an all or nothing standard that didn't apply. The other error that was made is that she held that this speech needs to be solely or primarily directed at the government, and that's error 2. This court has repeatedly held that's not the case. Again, in Blanchard, the speech was primarily directed at protecting the reputation of the hospital. The statute says that the statements need only be reasonably likely to encourage public participation, reasonably likely to encourage consideration or review by the government, or made in connection with a proceeding. That is a far lower standard than was applied to us in the trial court, which was a solely or primarily standard. And after that erroneous standard was applied, well, then it was quick work because the court held that our statements were motivated by a commercial purpose.
So if we agree with you that some of this is advocacy, but some of it may be fraud, how do we do the parsing you're talking about? Because I get it that some of this may very well be your advocacy on behalf of, the oil companies and their views. That I get, but at the same time, there's an underlying factual component similar to what I was talking about in the cigarette cases, where there are allegations that you're misrepresenting factual information dramatically. How do we sort through that difference when you weave it together with advocacy?
Well, Your Honor, that's what Blanchard authorizes, for us to move into separate categories, the protected petitioning activity, put that in one category, identify in each paragraph. I know it's a long complaint, but we would be happy to assist the court in identifying the passages that are specifically directed at petitioning activity. Our position is that all of it is, but that would be something that we would argue in front of the trial court, and you'd go through paragraph by paragraph and then excise so that the protected petitioning activity cannot form the basis for claims that are brought against the company. Could very well mean that the case continues, as you're describing, on the basis that is not protected activity, but it should not be the case that a civil action proceed where the claims are based on protected petitioning, which is what the Superior Court found.
Okay, thank you.
Great. Thank you, Your Honors.
Attorney Schofield.
Thank you, Your Honor. Chief Justice Budd, and may it please the court. Seth Schofield on behalf of the Commonwealth. I'd like to begin with your question, Justice Wendland, which is how does this make sense? And the answer to that question is categorical. It does not make any sense. And in fact, not only does it not make sense, it's not supported by the statute's text, its structure, its purpose, and history. In part due to the policy concerns that the court was expressing earlier, in particular Justice Kafker, in terms of shutting down a law enforcement action that's intended to protect the public interest under express statutory authority in Chapter 93A. And it's especially untoward in this case where numerous courts have already rejected the assertion that the Attorney General's motive for pursuing ExxonMobil under Chapter 93 is based on a disagreement with Exxon's viewpoints on climate change policy.
But isn't some of, I mean, I get that this may have serious consequences to the ability to enforce actions, and that may mean the AG is outside of the anti-SLAPP. But if you are within the anti-SLAPP, there's a lot of policy back and forth going on here. You know, they do have a right to, you know, advocate for their energy beliefs. And can we really carve out the factual misrepresentations here that you allege from their advocacy, because it's so woven together? I'm just trying to understand how we do that.
Absolutely, Your Honor. And I think when Your Honor reviews the complaint, and we acknowledge that it's very long and very detailed, and it will take some time to do that, it will lay bare the fact that the claims in the complaint, there are 3 of them, have nothing to do with Exxon's advocacy on climate change policy or energy policy. The purpose of the complaint is set forth in paragraph 2 of the complaint, where it's very clear. It says, I quote, "The Commonwealth of Massachusetts, through its Attorney General, brings this action to hold ExxonMobil accountable for misleading the state's investors and consumers." In its reply, Exxon points to 2 incidents where it suggests that the Attorney General's 200-page complaint may refer to some activity that constitutes petitioning. But that is a far cry from saying that somehow Exxon can satisfy this court's test that the Attorney General's 3 Chapter 93A claims are, quote, solely based on ExxonMobil's petitioning.
Do we have to do, is it an all or nothing? Again, I understand it's all or nothing if the anti-SLAPP doesn't apply to the AG. But is it all or nothing, or do we have to do a parsing? Even you concede there's some improper reliance on advocacy. You say a tiny amount, right?
Well,
but do we have to do that parsing if some of it is, or is the trial judge right that if it's not, is it an all or nothing, or do we change that standard?
Yeah, I want to clarify one point and then answer your question, which is we do not agree that there's any improper reliance on petitioning in the complaint. I want to be absolutely clear about that. There are some references to advocacy by ExxonMobil, in particular the 2 activities that Exxon refers to in its reply, a covert Facebook campaign to advocating against federal fuel economy standards, vehicle fuel economy standards, and then advocating.
So what do we do with that, for example?
It's context, Your Honor, for the claims in the complaint. The claims aren't based on those activities. It instead, the claims, and I'm happy to go through each one, but if we focus just on the consumer claim, for example, in count 2, the claim is that the Commonwealth alleges that Exxon violated Chapter 93A by deceiving Massachusetts consumers by misrepresenting the purported environmental benefits of using its fossil fuel products and failing to disclose to Massachusetts consumers the fact that using the production and use of its products are a leading cause of climate change. That claim is based on advertising at hundreds of ExxonMobil branded service stations in Massachusetts, its Rewards Plus point-of-sale smartphone application, which allows consumers to purchase ExxonMobil fuel at the station and also serves as a vehicle for advertising the products to Massachusetts consumers, and its consumer-directed product promotional website. That's what the claim is based on.
Doesn't,
Allegations about the
don't
phase.
those have to be factually inaccurate, right? That's going to be a key component, because if it's factually accurate, they're allowed to say that, right? I mean, you're having to establish unfair and deceptive practices under 93A, right? I take it you're going to have to establish the falsity of that information, right?
Well, Your Honor, we have a deception claim, so we have to establish on summary judgment or at trial, ultimately, that those advertisements and marketing were deceptive because they misled consumers about the benefits of the products, and failing to disclose that actually using the products doesn't reduce emissions, doesn't help the environment, but is actually contributing to climate change.
And more importantly, that ExxonMobil knew it at the time they did it.
Absolutely, Your Honor.
Okay. How do I tell between the difference between improper basis of a claim on petitioning activity versus what you're calling context?
How do you tell the difference, Your Honor? Well,
Right, that seems to me that if you're punishing ExxonMobil for its viewpoint or its petitioning activity, that seems wrong. But you're saying that that stuff comes in to give the complaint a fraud context.
yes, Your Honor, and we agree that Exxon has every right to engage in lawful petitioning.
Right, but if anti-SLAPP, and this is a big if anti-SLAPP applies to the Attorney General, and we go through the Blanchard test, how do I parse out, as Justice Kafker was saying, the information that stays in, the kind of factual basis that stays in, because it is not solely based on petitioning, and what you just said was context?
Well, Your Honor, I think the first point is an important one, which is the court in Blanchard and other cases has said it's a claim-by-claim analysis, not a paragraph-by-paragraph, allegation-by-allegation analysis. What the court does, and what the Superior Court did here and correctly found, in our view, was that the claims are not solely based on Exxon's petitioning. They are based on its advertising to consumers. They're based on marketing to consumers. They're based on private communications with Massachusetts investors, where our position is that they misrepresented material facts about the risk climate change poses to financial markets and the company's value. Those are not petitioning activities. They therefore provide a substantial basis for each of those claims. The fact that a complaint, the court has never held that a single reference to petitioning automatically results in dismissal of an entire claim. In fact, I believe it's 477 Harrison, the court affirmed the denial
But
of...
petitioning is defined so broadly, is made in connection with an issue under consideration or review by any governmental proceeding. That's really broad language, right? That's right from the statute. And when we're talking about one of the major issues in the Commonwealth right now, energy policy, right? That's what's at stake here. And it's hard to draw lines on what that sentence means, is made in connection with an issue under consideration or review by any governmental proceeding. It's just, you know, if you don't win all or nothing on the AG point, this becomes pretty complicated to sort out that, right? Petitioning is defined extremely broadly in our case law. And that's what makes this thing super complicated, right?
We agree that the definition is very broad. I disagree with the premise that the communications that the Commonwealth is relying on to support its three claims falls within the definition, albeit broad. for petitioning.
Do
I
the-
think there's a
can you-
fundamental line.
Walk us through a little bit, the green, I can't remember, green branding or whatever the language is,
Greenwashing, Your Honor.
greenwashing, which is a loaded term, right? I take it that's a play on brainwashing? What does that mean?
What greenwashing means, and we included a definition in our brief that will be helpful for the court's review as well, but greenwashing is essentially a brand marketing campaign where companies tout their environmental accolades in an effort to draw in more consumers, and notwithstanding the fact that their actual environmental record doesn't match what they're telling the public.
You give an example of the algae, right? How they're sort of putting out half the facts on that. But again, does that get into petitioning? Because, other people can fill out the facts. I worry like that claim, doesn't that claim involve sort of advocacy are there factual misrepresentations as well as omissions in that? Are they providing incomplete explanations, which I guess you're allowed to do in petitioning, right?
Well, you can't engage in petitioning fraudulently. That's not what we're talking about today.
But is the greenwashing claim include fraudulent allegations too?
It does, Your Honor. And the
Give
one
me
that the
could you give a couple examples of the fraud and the greenwashing?
Of course, and again, it's a deception. The terminology is fraud is a big category that covers a lot of different types of deception, misleading statements, et cetera. But our claims are essentially deception claims. But in the greenwashing context, and I will refer the court to the one the Superior Court found compelling, which is the Protect Tomorrow Today campaign that Exxon uses to tell the public. Essentially, it says in that campaign that it defines its approach to the environment. And one of those approaches is to protect the environment for future generations. Now,
Right, but, I get you think they're doing a terrible job at that, but is that petitioning? When they do that, does that meet the definition of any written or oral statement made in connection with an issue under consideration or review by any governmental proceeding? How do we say that's not? I'm just trying to understand how we get there.
Yeah, you say that it's not because the objective intent of that campaign is to solicit consumers to purchase ExxonMobil fossil fuel products.
But is the intent, I thought we don't do that intent analysis at that first stage.
You can look at objective intent, not subjective intent. And I think there's a clear line that the court can draw between communications that are clearly intended to advocate for a policy position, support a regulation, don't support a regulation, because it's in the company's financial interest. And distinguish that situation, which clearly is petitioning, from a situation where the company is advertising gasoline, for example, to consumers at a gas station to sell the product. That's clearly motivated by an objective intent to sell a product to a consumer. And I think that's one way to get at the issue that you're raising, Your Honor, which is, I think that's a clear way to draw the line. Again, but we acknowledge that the definition is broad. I will say that Exxon hasn't pointed to very many specific examples in its briefs of specific things in our complaint that it says qualify as petitioning. In the reply, it's really two: the Facebook campaign and the campaign trying to convince the European Union Commission to withdraw strict greenhouse gas emissions. So I think that actually speaks volumes to even Exxon's perspective of what our claims are about.
That is a clear petitioning activity, right?
I think that clearly could qualify as petitioning, Your Honor. But again, that's 2 paragraphs out of 770 in a 200-page complaint. That clearly does not satisfy.
Are those 2 examples then falling under your context
Yes, Your Honor, they provide context for Exxon telling consumers and telling investors that it's supporting environmental protection, it's supporting stringent greenhouse gas emission standards, but then secretly behind the scenes, it's doing the opposite.
Can I ask one last question with your permission?
absolutely.
So your inability to move forward and enforce, they're saying you're proceeding. One thing that worries me about these anti-SLAPP cases is that they totally transform the way litigation is done in the Commonwealth in general, that we end up fighting the anti-SLAPP cases for years and don't get to the merits. Is that happening here or not?
That's exactly.
Counsel for Mobil says you're proceeding, you're doing your investigation, you're doing your discovery. Is that the case, or is there a monkey wrench in this process?
It is absolutely a monkey wrench in this case, Your Honor. I would say we can divide this up into categories. From the period when they filed the special motion to dismiss, there was an automatic stay on discovery, and nothing happened. After the court decided the special motion to dismiss, there was a period of time between the decision and when the appeal was entered, when the Attorney General issued some Rule 45 third-party subpoenas. But it was our perspective, and it was a perspective that was suggested by the Superior Court last week, that during an appeal, the appeal under the anti-SLAPP statute has the effect of not allowing at least party discovery during that period. And the parties have not engaged in any party discovery. In fact, the Commonwealth has, because we're nervous, because we've been waiting for so long to move this case forward, we filed a motion under Rule 27B of the Rules of Civil Procedure, which authorize a party to seek to perform a deposition to perform trial testimony pending an appeal. So that's the extent of it, but we used the procedure that was available to us, absent being entitled to engage in full party discovery pending the resolution of the appeal.
You spent most of the time talking about how this would work if the SLAPP statute applied, but I think you said at the outset that you didn't think it applied at all. Is that correct?
Yes, Your Honor. We do not think that the statute applies. We think it's very clear from the text, the structure, the purpose, and the history of the act that the statute does not apply. As a textual matter, there is a well-settled and widely accepted rule of construction that the government is not included in a remedial statute like this one unless the legislature expresses that intent.
What about the town of Hanover?
Town of Hanover.
That's a government, right?
Yes, Your Honor. No, well, it's a municipality, Your Honor,
Yeah.
and that's one way to distinguish that case. But I think more importantly, the issue simply wasn't raised in Hanover. The court had no occasion to consider that issue in Hanover. So I think that Hanover doesn't, it's a municipality, wasn't raised, it doesn't stand for, it doesn't carry any precedential value as to whether the statute applies to an action by the Attorney General to enforce state law on behalf of the Commonwealth. And again, I think what Exxon does is ask this court to flip that baseline presumption and assume that the Commonwealth is included unless the legislature expressly excludes the Commonwealth. But that's not the way the rule works. That's not what this case's opinions say. And I think, Justice Wendland, it was as you that asked about Section 6E. We don't need to speculate or wonder whether the legislature was aware of this rule, because in Chapter 231, the same chapter that the anti-SLAPP statute appears, in Section 6E, they define the term party to include agencies and officers of the Commonwealth, but decided not to apply that definition to the anti-SLAPP statute.
Now, can you respond to counsel's argument that that was because under the American rule, everybody pays for their own, but if you want attorney's fees, you have to actually set it forth?
That's wrong, Your Honor. The
Well, I
anti-SLAPP
take that.
statute.
That's not really a response.
Well, yeah, let me. The anti-SLAPP statute also includes an award of attorney's fees and costs, and that's part of our structural argument, which is if the legislature had intended the remedy to apply to the Commonwealth, it would have been incongruous for the legislature to apply it, but then not also to expressly waive the Commonwealth's sovereign immunity to attorneys' fees and costs in the statute. In addition, Your Honor, in the second paragraph of the statute, the legislature gave the Attorney General a special role under the anti-SLAPP statute, which is aiding a party against whom a SLAPP statute has been made to intervene in the action to support the moving party. It simply can't be the case that where the legislature uses the word Attorney General in party in the same statute, that somehow party now includes the Attorney General. I think the legislative history, I know the court's been here, had a long day. I don't want to belabor the point, but I would urge the court to also review the amicus brief submitted by the former attorneys general, which very carefully reviews additional legislative history about the anti-SLAPP statute, and it makes clear that the legislative concern was with private misuse of lawsuits against petitioning activity. There's absolutely nothing in the legislative history that suggests the legislature had a concern about government misuse of lawsuits. Thank you, Your Honor.